Thank you for joining me. Before I begin this presentation, I wanted to go over a couple of quick disclaimers, really 6. You didn't think you'd get a presentation from an attorney without a few disclaimers, so we'll go through them quickly. First, I want you to understand that I'm not the Securities and Exchange Commission. I'm also not the receiver who was appointed in the SEC's case against Mr. Woods. I'm not the receiver. I'm a private attorney licensed in New York. I'm interested in pursuing arbitration claims against New York-based brokerage company Oppenheimer. I'm not providing you with any legal advice if you're a victim of the Horizon Ponzi Scheme. To the extent that you're seeking legal advice from me, that advice would be to retain an attorney who's competent and who can guide you through these issues as they're highly complex. And I'd like that attorney to be us. I also want you to understand that the information that I'm providing for you is based on allegations. There's been no factual finding of liability against any of the parties, including John Woods or Oppenheimer. Finally, I want you to understand that all the documents that I'm showing you in this presentation are public documents contained in a court docket. Nothing is based on, nothing is confidential, and I'm not revealing any client confidences. With that being said, why am I here today, and what am I here to talk to you about? So I'm here to talk to you about first the Horizon Ponzi Scheme. What was it? What are the SEC's allegations against John Woods and against Southport? And secondly, why investors would be smart for pursuing individual securities arbitration cases against a company called Oppenheimer. And at the second half of my presentation, I'm going to make the case for the claims against Oppenheimer and why I believe those are strong cases. So first, I'm going to put up on the screen for you the SEC's complaint against John Woods. So what does the SEC say happened here? So the SEC says Woods and other investment advisors at Southport told their clients that they would receive returns of 6 to 7% interest guaranteed for 2 to 3 years in a non-specific investment fund called Horizon Private Equity. Now, in reality, what Horizon Private Equity did, they didn't invest in actual investments. They raised money simply to pay back old investors. And what the SEC is describing in this paragraph is a classic Ponzi scheme. And so you have to ask yourselves, did investors know, or should investors have suspected that Mr. Wood and his cohorts at Southport were involved in a Ponzi scheme? And my answer to that question is certainly no. And I say that with confidence because by all outward appearances, this investment appeared to be legitimate, at least to the investors, not to the people who should have been checking things, and not to the people who were in charge. And I'll talk to you later on about those people when I talk about Oppenheimer. So what I have up on the screen for you now is a copy of a confidential private placement memorandum, or what purports to be a confidential private placement memorandum for an investment called Horizon Private Equity LLC. So I can tell you, as an attorney who's experiencing looking at documents like this, just on its face, there's nothing about this that looks suspicious to me. So to an investor, when you're presented with documents that look like they've been prepared by an attorney, that look official, certainly there'd be no grounds for you to be suspicious. The next document that I have up on the screen is a sample account statement that Horizon Private Equity 3 provided to investors. Again, there's nothing particularly unusual or suspicious about this. It seems to be just an account statement that will be provided for any investment. There's nothing suspicious about it at all. So why am I here today, and why do investors need to protect themselves by pursuing third parties? The answer to that question, or for the answer to that question, you don't need to go far. All you need to do is look at the SEC's complaint against Mr. Woods, and you can see, even in the SEC's complaint, it talks about how Mr. Woods, Southport, and the entities that he controls are undercapitalized. So it says here, the assets owned by Woods and the entities under his control, including Southport and Horizon, are worth far too little for there to be any realistic prospect that the Ponzi scheme will be able to pay back existing investors their principal, let alone their promised return. So what's the bottom line? The bottom line is investors may not be made whole by the SEC's case against John Woods. So if you're an investor in the Horizon Ponzi scheme and you're waiting for the SEC case to conclude to see what happens, it's probably not a good idea. And the reason why it's probably not a good idea for you to wait to see what happens is because there's not going to be enough money at the end of that case to be distributed to investors. So investors aren't going to be made whole. And so what investors often do in situations like these is they look to other third parties who may be legally liable to them for damages. And in this case, what I'm suggesting to you is that Oppenheimer's that party, that Oppenheimer is legally liable to investors for their damages in the Horizon Ponzi scheme. And so what are the basic allegations against Oppenheimer? So, everyone knows, or many of you who are watching this video knew that Oppenheimer employed Mr. Woods. So the first thing is that Oppenheimer knew or should have known about the Ponzi scheme. And the second was that it was negligent in enforcing its own rules, as well as the rules of the Securities and Exchange Commission and the rules of the Financial Industry Regulatory Authority. And so, I'm gonna go through a few documents and show you what my case is now against Oppenheimer. I believe that I could build a case against Oppenheimer. And the first document that I have up on the screen for you is an account statement. And this is an Oppenheimer account statement, and it identifies John Woods as the financial advisor. And you can see that there's a second arrow, and that second arrow identifies an investment in this account, and that investment is an investment in what purports to be a direct investment in a fund called Horizon Private Equity Fund 3. Now, we all know, based on the government's allegation, that isn't a real investment, right? So without going into particular detail about what Oppenheimer may have done wrong, this document is a significant problem for them when you talk about their liabilities, and when you also talk about their violations of SEC regulations. Certainly they can't put a security on an account statement without doing some due diligence. At minimum, they have to verify that the investment's actually real, right? And there's more complexities that go with that, but it's far outside of the scope of what I'm doing today. The next document that I have up on the screen is an incoming wire transfer request, and all of the victims of the Horizon Ponzi scheme sent money through Provident Trust Company. And I should say, again, my disclaimer here, not alleging or not implying that Provident Trust Company did anything wrong. I want to draw your attention to two arrows here. One arrow shows that it says current custodian account. You see here it says Oppenheimer & Co. for benefit of. The rest of that information is redacted. The rest of that information with customer information is redacted. So what this shows is that money was coming from an Oppenheimer account, and it was going into Horizon Private Equity. You see here it's a transfer from Oppenheimer & Co. to Horizon Private Equity. And again, without going into great detail about Oppenheimer's obligations with respect to anti-money laundering and their obligations under other securities regulations, this is a problem, right? And I think that even a layperson can understand that this is a significant problem. Now, the next slide that I'm going to show you, if you couldn't understand or if you didn't appreciate how those other slides were a problem, certainly you could understand how this is a problem for Oppenheimer, and a really big one. So what this is or what this document purports to be, is it purports to be a presentation by John Woods, or a presentation that Mr. Woods gave while he was still an employee of Oppenheimer, and this presentation purportedly pitched Horizon Private Equity to investors. So that's my case against Oppenheimer, and that's my law firm's case against Oppenheimer in a nutshell. And there's certainly more nuances to it. I can explain there's very specific and very technical violations of securities regulations that we're just not going to go into in a video like this because it doesn't make sense. But one of the last things I want to leave you with, and one thing that I want to make sure that everyone understands, is you don't have to be a customer of Oppenheimer to bring one of these cases. So this is a very significant point. If you never had an account with Oppenheimer, you could still bring a case like this. If you never wired money from an Oppenheimer account to Horizon, that doesn't matter. If you're an investor in Horizon, you may have a claim against Oppenheimer, so you should still contact our office to discuss that case. And so lastly, what am I offering you? So I'm offering a free phone or Zoom consultation. I'm also offering to represent any victims of the Horizon Ponzi scheme on contingency. So what that means is I wouldn't be paid anything unless I'm able to recover money on your behalf. If you have any additional questions, you can call me. You can also email me, and that information is below. Thank you.